Hello, good morning, good afternoon, and good evening, especially to our dear speakers who are joining us from the other side of the world. My name is Fereshteh Rafieian. I'm the Science Program Specialist for Science Policy and Capacity Building for Sciences here in UNESCO Regional Office in Jakarta. It's a pleasure for me to welcome you to the 7th session of our series of webinars on implementing the UNESCO recommendation on open science. So today we are honored to have two distinguished speakers with us, Professor Richard Gold, who is a distinguished James McGill professor from the Faculty of Law and also a founding director of Center for Intellectual Property in McGill University, and Dr. Monica Granados, who is the Director of Open Science at Creative Commons. At this 7th session, we are aiming to explore intellectual property rights as enablers for responsible open science. As I mentioned, this is an effort and a part of a bigger project for capacity building in the Asia-Pacific region for implementing the UNESCO recommendation on open science. The UNESCO recommendation is the first international instrument on standard setting for open science, creating a international framework for collaboration on open science. It provides the first broad definition of open science as a movement that brings different practices and principles that enable collaboration and information sharing for the benefit of science and the society. It aims to engage wider society in also creating and evaluating and communicating scientific knowledge and ensure that multilingual scientific knowledge is open, accessible, and reusable for all. In this definition, open science goes beyond the outputs of scientific process and includes the whole process of science as a human right for everyone to be able to participate in and benefit from the outcomes of that. The definition has four main pillars, which are open scientific knowledge and includes scientific publications, open access scientific publication, open research data, open educational resources, open hardware and software. And the second pillar is open science infrastructures, which includes both virtual and physical infrastructures, including platforms for sharing data and publications, and also any platform that enables participatory practice of science. The third pillar is open dialogue with other knowledge systems, including indigenous people, including marginalized scholars, and engagement with local communities. And then the other one is open engagement with societal actors from practices like citizen science, participatory science, scientific volunteering, crowdsourcing for research. So as you see, this is quite broad, and in these webinars, we are aiming to really shine light on every aspect of open science, understand its relation and relevance to science practicing in our region, identifying the challenges, good practices, and also hoping building a stronger community of open science actors and stakeholders in our region. The recommendation particularly emphasizes that the existing international legal frameworks are, so the recommendation is in line with the existing international legal frameworks, in particular the intellectual property rights. We do have another international intergovernmental organization which is in charge of IP rights, WIPO, and we have been working in consultation with them also to develop this recommendation, and now working with them to prepare, some toolkits for informing whoever wants to practice open science in line with intellectual property rights. So the recommendation emphasizes that the right of the scientists to their scientific products is secured, and it acknowledges that while the practice of open science is based on the values of collaboration and sharing, it builds on existing intellectual property system and fosters an open approach to amplifying access to knowledge by everyone for the benefit of both science and the society. And it also promotes opportunities for innovation and participation in the co-creation of knowledge. It emphasizes that access to scientific knowledge should be as open as possible, and the restrictions need to be proportionate and justified. When it comes to as open as possible, as closed as necessary, as we call it, restrictions need to be justified on the basis of protection of human rights, national security, confidentiality, right to privacy and respect for human subjects of studies, legal processes and public order, protection of intellectual property right, which is the topic of discussion today, personal information, and sacred and secret indigenous knowledge, and rare and unrare and threatened and endangered species. This is something that we tried to address in the last session of the webinar, where we had indigenous scholars as speakers. So today we are very glad to have you with us. And like always, we ask you what is the level of your familiarity or engagement with open science. We are happy to see that the portion of the people that are practicing open science or are aware of that, but not yet involved in it is increasing in our audience. And the portion of the people who don't know much about open science is decreasing. We hope we have played a role in that. We also ask you which groups of stakeholders you represent. We see again an increase in the number of researchers and academics and policymakers from governmental sections. We do have university lecturers, librarians, data and archive managers, students from universities. We have colleagues from international organizations, private sector, school teachers, and other participants. We kind of know which countries you are from, but from the people present in the session, I would like to invite you to please scan this QR code and tell us which country you are from. We will have 2 more questions during the session for you. It would be good for us to be able to correlate your answers to where you come from to better understand what would be the challenges and the interests of participants from different countries. So please feel free to scan the QR code. My colleague Fitri is sharing the screen to see your answers. We have a lot of participants from Indonesia and Philippines and Timor-Leste. Thanks for joining us. We have participants from Singapore, China, and Australia. Okay, Philippines is getting stronger. Thailand, nice. We have participants from Pakistan. In the chat, I see that. Welcome to the session. So please keep answering the question. If you haven't done it, this is the last chance to please scan the QR code. The link is also in the chat, and you can use the code to access these slides. It will be the same code for the next slides. So with this, I would like to invite our first speaker, Professor Richard Gold. Thank you so much for joining us. I know it's very late for you, both of you. Thanks for adapting your schedule to our region. It was actually, I want to confess that this is a very challenging topic, and it was very challenging for us to find experts in our region who would have expertise on IP rights, but at the same time on open science. These 2 areas in the first glance may look to many of the science community people as, I don't want to say it, but I know that's the reality, that many people think that these are 2 clashing areas. But today we want to show that this is not the fact. So Richard, thank you so much for joining us. I would like to invite you, please, to give us a broad overview of what is IP right and how it connects to open science. And I hope to listen to, for us to listen to some of the good examples you have from your work in the field of health and medicine, from how IP rights can actually enable open science. Thanks. The floor is yours.
Well, thank you very much. Thank you all for joining. I think we're literally, if you dug a tunnel from where you are through the center of the earth, you'd arrive where we are. And it's, Monica and I both have some ties to the same university, McGill. And it might be that Canada, being a middle power and trying to find its way in innovation, is one of the places where you see a lot of experimentation with open science. So I'll share my slides with you. So hopefully you can see them well. So as I said, I'm a professor at McGill University. I'm also the Chief Policy and Partnerships Officer of a nonprofit called Conscience, which obtains funding from the Government of Canada. And what we do is we promote open science drug discovery. And so we really get into that clash, or the appearance of a clash, between intellectual property and open science. So my basic argument is, and I usually do this so that, if people want to fall asleep, they can after they see the overview. It is exactly this point, that open science is really a strategy about how to advance science, how to advance innovation. And intellectual property is one among many tools to get there. Intellectual property has never been the goal of anyone. It is always a tool that's justified in order to help us advance science, and more particularly advanced innovation. And so the argument I'll be taking you through is that we can actually use intellectual property in a way that supports open science, with the goal of achieving faster, more efficient, and more equitable innovation. So that's what I will walk you through. Of course, my screen decides not to advance. Sorry about that. Not sure what's happening.
Do you wish to stop sharing and reshare?
I might stop sharing and we'll try again. Okay. So let's see if this, yes, okay. So I'm going to start off. Thank you for that. At 11, 15 at night, my brain, I'm usually asleep by now, so I might be a little bit slow. And if you can't understand what I'm saying, or it appears that what I'm saying is incoherent, please tell me. It's probably just that I'm tired. So I'm going to start off talking about intellectual property and introducing it, and introducing open science, before getting into, in part two, some examples. So intellectual property is not one thing. It's a term that came about at the late in the 19th century to put together a whole bunch of different tools that government set up. So the first thing is that these are government created. They're artificial. They're not natural rights or anything. These are decisions that governments took and introduced legislation, for the most part, to create limited rights. And they're limited both in terms of what they cover, the kinds of things they cover, and in terms of time. Monopolies over ideas, and I'll break that down a little bit. So it's not a property right like in your house or in your car. It's in an idea, and because ideas are hard to define, we put limits on it so that they don't extend too far. And the idea is to induce the private sector to invest in the creation and delivery of new products and services. And to be frank, intellectual property has very little to do with creating ideas, because as humans, we naturally create. It's the process of taking a raw idea and turning it into a product or service that takes a lot of effort, a lot of time. Much of it is boring, and it's sometimes quite expensive. So it's that translation process that intellectual property is particularly important for. There are different kinds of intellectual property. I'm not going to list them all. These are the main ones that I think relate to open science. So one type of idea are artistic work, so paintings and sculptures and drawings and things like that, but also films, plays, dance, dance moves, and so on, and software, which doesn't seem all that artistic, but was lumped in there. All of those are protected through copyright rules, and there's certain treaties administered by WIPO and some rules that also come from the World Trade Organization that shape what copyright has to look like. There are also a different set of ideas which are around names and symbols, and this is protected by trademark. So if you know the Nike swoosh, that symbol is protected by trademarks. Other areas like biopharmaceuticals, chemicals, mechanical devices, these are generally protected by patents. And in addition, there's a special protection. These aren't technically intellectual property, but they're generally lumped together over biopharmaceuticals. And this is data protection. That is the data that is used to demonstrate the safety and efficacy of drugs cannot be used by just anyone at any time. As I said, they have different limitations. So one is how long do they last? Copyright, for example, lasts for the life of the person who created it. It has to be a person, not for the most part in most countries, AI. It has to be an actual person, can't be a corporation. Their life plus 50 or 70 years. There are some exceptions for government works and so on, but that's the general rule. So it lasts 50 or 70 years, depending on the country, beyond the life of the person who created it. And so no one else during that time is allowed to reproduce that. So if I have a book, no one else is allowed to reproduce and sell that book without my permission, at least not legally. Trademarks can actually last forever, but they have to be renewed every 10 years. So trademarks are, as I said, these symbols, these names, Hertz, Nike swoosh, the name Nike, are all protected. And generally in most countries, every 10 years you have to apply and make sure that it still serves the function. I can get into details about it, but it potentially can last forever. And then patents. Patents last for 20 years from the date one applies for it. In some countries, mostly in high-income countries, there's often or usually some extra protection that's given that ranges from 2 to 5 years. After that, anybody's allowed to use the idea. So, just based on my own culture, Shakespeare, what he wrote, anybody can copy it. Anybody can sell Shakespeare's plays. Anybody could perform Shakespeare because he's long dead. So we're well past that deadline. The same thing for if you don't renew a mark, that symbol then falls into the public domain, as we say, and anybody can use it. For a patent, 20 years after I applied for the patent, anybody's allowed to use it. So medicines developed 100 years ago, antibiotics and so on, can be freely produced by anyone without concern about patents. So I gave you some examples of copyright, but more technically, copyrights prevent the copying or the incorporating of the expression of an idea. So it's not an idea itself. So if you think about Romeo and Juliet, I know I'm using Western examples here, but the idea of star-crossed lovers cannot be protected because that's a bare idea. But the expression in a particular play, so Romeo and Juliet and West Side Story, which was produced less than 100 years ago, are the same basic idea, but expressed differently. And so each one could get a copyright. And right now, if you took something similar expression to West Side Story, I think it's still subject to copyright. Well, it would have been 1960s, and therefore it would be a violation, and the person would be able to sue you. For trademarks, it's using a name or symbol in a way that confuses customers. So I can talk about a Nike swoosh. I can use the word Nike. I can use the word Coca-Cola in this talk because I'm not selling you anything. I'm not confusing you about its source. The protection is limited to someone else selling a product or service in conjunction with that symbol or that name in a way that is confusing to the consumer. So I either use the exact name, in which case it would be confusing, but sometimes even a modification of the name. I change a couple of letters. I change the symbol a little bit. Instead of the Nike swoosh being on the particular angle it's on, I change the angle. Even that would be caught by the protection if it were confusing to the customer. Finally, what patents do, they prevent other people from making, using, selling, or importing a product or process that's described in the patent. So I have to describe a series of steps for a process, or I have to describe a particular product. So if it's a chemical, I put the chemical formula. If it is, and there's some very strange ones, there are patents in the United States for to prevent dogs with long, fluffy ears from their ears going into the food they eat. Looks like toilet paper rolls that they put on their ears. That could be. I describe that invention. I show pictures, and it's protected. Now, why do we give these things? So I want to, and this is this is the economics 101 of patents, the justification for them. So this line here, can you see my cursor as I move it? Yes, okay, good. This line is the cost of doing research, of producing the knowledge, okay, for a firm. This line is if they develop it, how much money will they make from selling it? They'll either sell the idea or eventually sell a product that incorporates it. This line, the top line, the green one, is the value of that invention or that idea to the public. So think about something as simple as Happy Birthday, the Happy Birthday song. Someone created it. But the value to it is, for our kids at birthday parties, at all kinds of events. We're using it all the time. But the person, if they had a copyright in it, would never be able to get that full value. The value they get is lower. It's what they could charge for it, the people they can find. So there's always a difference when you're talking about an idea between what the particular company can make and what we as a society get from it. Think of the same thing for a drug, right? So the company can charge something for the drug, but think about the lives saved, the work that person can do, their contributions to their family, the attachments that the family has to this individual from that saved life. So the value of the invention far surpasses whatever a company can get. So this is the world without patents. And so what you notice is the ideal amount to produce is Q star, right? Where we maximize the social value, where the public gets the most they can. But if you look at where the line crosses for the private, they'll only produce this much knowledge. They won't produce this. And so this amount in the pink triangle is lost. We're underinvesting in the research. We're not getting it. So we can fill that by either governments stepping in and putting in extra money to cover that, but most governments don't do that to any great extent. They don't have the means to cover that full value. And so there's generally a loss, a certain loss of the total benefit we could obtain from ideas. Well, when you have a patent, you're essentially allowing the company to capture more value. How do they do that? They prevent other people from being able to sell the product and making money themselves. They keep that all to themselves. So they're able to capture more of the value of the product, and that's the blue line. And therefore, it intersects with the cost at this point, which is much smaller than we saw before. So there's still underinvestment, but much less with a patent than in circumstances where there would be no patent. The problem is there's another cost that I couldn't put onto one screen here, is that once you have a monopoly, it's not only important for creating the innovation, for having enough incentive to create the idea, it also affects the product market. So when the private company has a patent, they charge the public more. So a pill that might have cost them 50 cents to produce, they might be selling at $10. And they capture that extra value, which gives them the incentive to invest more in the research. But of course, a person who could pay 50 cents but can't pay $10 won't be able to access that life-saving drug. And so there's a cost at the end that we are limiting access because affordability has gone down. The product becomes more expensive, and therefore there'll be people who could benefit from the drug and who could pay for it if there were no patent, but can't pay now. That's called a deadweight loss. So patent systems and intellectual property systems try to balance these two, but there's always a cost to somebody. And so patents are a particular form of balance, if you wish, to try to get firms to invest more, but the things they produce might not be accessible to many people. And when we're talking about pharmaceuticals, particularly in low and middle income countries, is where you see it. So let me contrast that with open science. I'll come back to how the two can work together. There is really no single definition of open science. So UNESCO has its definition. I think the OECD has its definition. There was an article a number of years ago, 10 years ago, that found 5 different definitions of open science. I have my own. Everybody has their own. There's no single definition, but we can say it's a set of practices that ensures that researchers doing the science, it could be firms, the public, if you want to talk about citizen science, or people who just want to understand the science. They might not be citizen scientists, but they're people who are looking at taking a drug and they want to understand its side effects and its benefits and so on. All have access to scientific and technological knowledge. It has, at least in my field, that's what it is. Obviously, it could also apply in UNESCO's definition to a wider set of products, but I tend to concentrate on technology, especially biomedical. Some of the practices that are fairly universally included is open sharing of data, subject to personal data, especially for patients, but it could be other personal data as well. So we try to make data as open as possible. Open publications so that the end result of research is made available to readers around the world, as long as they have a connection to the internet, which is a separate issue. They should be able to access the results and the tools and materials that go into it. Because sometimes if you don't have access to the same materials, it's often very difficult to replicate the same experiment. So it includes sharing, subject to some limitations, but as little as possible. Now, what I work on and the examples I'm going to give you are a special kind of open science. And these are what I call open science partnerships. They're designed not just to share, right? Open science is a principle of sharing, and you don't necessarily know how people are going to use it. But the idea is knowledge belongs to everyone, and therefore we should share it. Open science partnerships are more mission oriented. They aim to effectively lead to some type of either scientific or technological outcome. Could be somewhat broad, could be narrow, it could be in different fields. Again, my area tends to be in biopharmaceuticals, but it could be anywhere. So they're partnerships, they're usually public-private. So usually there is some private industry. There is almost always, or maybe always, some public research entity, many times several of them, usually has some type of governmental or philanthropic support. So you could, think about creating. There's something called ASAP that is related to an organization called Drugs for Neglected Diseases Initiative to come up with molecules to solve the next pandemic. That could be its mission. So they're mission oriented. They tend to be bottom up, so it's not government saying, okay, we need this. It comes from the research community, it comes from the public, it comes from the foundations, it comes from the firms who decide we need this, and then they seek government support. They're designed not just to produce knowledge, but to translate that knowledge into real products and services that have an impact. So that's the difference between this and open science in general. You don't have to have that impact, it's hoped for, but these are designed to deliver that. They also, because they're open, try to open up the field by having competition. Because everything's in the public, everybody could draw on that knowledge to produce products or services that compete with each other, trying to keep the price a little bit more reasonable. Intellectual property is used, but strategically and generally to the minimum degree necessary to achieve their goals. Okay, so let me take you back and I'll show you the logic here. Going back to Economics 101, which is about all I could teach you because I'm not an economist. So this was the situation before, as you remember. There's no intellectual property. There's nothing else. We lose the pink triangle worth of innovation because we're underfunding it. Okay, patents, as we saw, try to address this issue by increasing the returns to the private sector. What these open science partnerships do, though, is they actually reduce the cost. So if I go back, right, what intellectual property does is it increases the returns to the private sector. They make more money and therefore they're willing to invest more. In open science, we don't do that. We just decrease the cost. And we do that by leveraging everybody's knowledge. We take down the barriers such as long negotiations, not having access to data, having to recreate it, a lot of duplicative research. We create standards that affect not only our project, but everybody, because it makes things interoperable. It allows for the creation of large data sets that could eventually power artificial intelligence. So it decreases the cost. And so we end up at this point, which means if we compare to when we had a patent, we had that size triangle. We actually reduced the size of the triangle because we're lowering the cost, and therefore, even without a patent, there is still more investment. However, you might still want you also open up the opportunity for even more government investment. And by doing so, by going to the right, you actually increase the social return. So we benefit even more people than we would in a situation without open science. This doesn't mean you don't have patents, because this only takes you to a certain place. Open science doesn't work for everything. And at some point, you may also have patents to try to push the research a little bit further, especially when it's very expensive and requires a narrow set of skills. Okay. So the general point is, the way intellectual property works is it increases the return to the private actor who's investing, inducing them to invest more in research. Open science has a different way. It lowers the cost of doing research, and therefore, with the same benefit accruing to the private firm, they'll do more, they'll invest more. So let me give you some examples of this. I just realized I cannot see my time, so I don't know where we are. Sorry. Oh, did I just close
my
screen?
You have 3-4 more minutes.
Okay. So let me just quickly go through some examples. Cash. And these just illustrate it. So this is the use of open science partnerships to help develop new tools, AI tools for drug development. And so the idea here is there are a lot of companies that claim to have, all these new AI tools that will solve drug discovery. Most of them don't work. What this does, it says, look, let's find out which ones work and learn from each other. So what we've done through the CASH initiative is we identify a particular drug target, and we ask firms or labs, anybody can do it, to suggest, to predict molecules. And then we actually get those molecules, put them in the lab, and test them out and see which ones work. All that data is given to everyone. So if they come up with a molecule that's interesting, they get no patent on it. It's left open to the public. But what the firms gain is a knowledge about how good their predictions are, and they can improve their AI models. The pharmaceutical firms get to see which of these AI firms are useful. The research community gets to experiment with different things. And one of our winners was from Brazil. So really, it doesn't have to be a big lab. Anybody could win. These are 18-month competitions, but as I said, all the information is put into the public domain. So the AI firms retain their property rights in their models, but not in the things we do together. All of that is open, which means that we have a very simple agreement. You sign it, there's no negotiation. It makes it really quite simple. So I think we're on our 8th competition now. I won't take you through that. Another one that's very interesting coming out of the United States is in synthetic cell biology. And here, this was a community that was already practicing open science. A lot of their products were open, but they still hadn't advanced. They hadn't created the products that they were hoping for. So a company called BNext was created by some students, and they had support from philanthropy, etc. And what they wanted to do is bring the community actively together, not just having passive sharing of knowledge, but actually bringing them together to create what's called Nucleus, a completely open platform for the sharing of synthetic cell components. They just started, but and they share materials, protocols, documents, software. And now they're developing the rules about, well, how does someone use the components in this open platform and create proprietary products? What do they have to give back? What's the benefit sharing? So they're trying to work out these rules. Another one is M4K Pharma trying to develop a drug against a horrible pediatric brain disease. They're doing everything in the open. So these are funded by foundations, patient foundations, family foundations, governments, etc. And they're developing a molecule completely open. They have no intellectual property. They do use regulatory exclusivity, which I can talk about in the questions. And then just outside of healthcare, the Aarhus University is doing something in water and water treatment and urban water treatment, the same type of thing. No patents, public-private partnerships. So I spent a lot of time on the basics of intellectual property and open science. They both are trying to change the playing field for innovation. One by lowering the cost, the other one by increasing incentives. If we do these together in a smart fashion, we can maximize the benefit to the public, which is the end result. So I will stop there. Thank you.
Thank you so much, Richard. Very interesting for me as someone with a research background. That was a new word. It's quite sad that in the research curriculum, we don't learn much in many countries and many universities about IP rights and open science. But I loved how you ended that with these are two enablers when they work together. One question I have myself, and I invite everyone if they have questions about what you presented to share it in the chat. All the initiatives you shared at the end, are they international?
They all have international components, some more and some less. Be Next is, has most of the communities in the United States, but they have members in Asia, in Europe, and elsewhere. They tend to be in the richer countries because they tend to be going after problems that require sophisticated equipment and labs and so on. One of their goals is to democratize that and to have more partners abroad, but they haven't quite figured out how to do that. M4K is just working in Canada. So some of them only work locally, but they have international partners. But other ones that I didn't discuss actually have quite a broad international component. The Structural Genomics Consortium, for example, is another one, probably the oldest, and it has laboratories around the world, I think virtually on every continent.
It's very interesting to see how community build all of these initiatives are. Thank you so much. So I would like also to invite our audience, if they are aware of any such initiatives in Asia Pacific or anywhere. I see that we have participants from other parts of the world. So please feel free to share this information in the chat with everyone, and we keep track of these good practices. One question we have for the audience to see now that we had this general overview of intellectual property rights, I would like to ask you if you had any encounter or if you have used any of these IP mechanisms in your work. We have another Mentimeter slide for you. My colleague Fitri will share the slide, and we would like to know your answers. If there are options that you have used and they are not included in these three general choices, please put them also in the chat. Especially from our research community, our industry participants. Yes, people have used copyrights. We can discuss later if they are open or not. More people, copyrights are more common. Some people have not encountered that. More people. Yeah, if you have used anything else that is not listed here, please put that in the chat. Nice, that's quite diverse. Patents are increasing. Okay, I think that's reflecting the diversity of our participants also. Excellent. So the slide will remain open for you to answer. Please make sure that you have scanned the code. There is also the link again in the chat. With this, I would like to invite our second speaker, Monica, to please walk us through the very special and empowering case of open licensing that Creative Commons has been providing and how this has been used in emerging fields, especially the fields that more collaboration between different disciplines and between different countries is needed. Thank you, Monica. The floor is yours.
Thank you so much. And it's such a pleasure and privilege to follow Professor Gold, again, not only because, we are both McGillians, but I think he set a really good foundation for not only intellectual property rights, but specifically copyright. And having a strong understanding of copyright, as was mentioned, is really important for knowledge producers, because once you understand what copyright is and what your rights are, that knowledge enables you to then exercise those rights to make your work more open. And that really is the conceit of Creative Commons. It's a way to hack copyright. So I'm going to walk you through a little bit about what Creative Commons is, what the licenses are, what they enable you to do as a knowledge producer, and then give you some examples of where they've been, invoked and how that enabled greater access to knowledge and impacts. So what is Creative Commons? Creative Commons, if you haven't heard of us before, is a nonprofit that empowers individuals, communities around the world through technical, legal, and policy solutions that enable the sharing of education, culture, and science in the public interest. And how do we do that? How does Creative Commons enable sharing? It's really through underpinning as infrastructure for open sharing. When you think about open, there's multiple dimensions to it. There's multiple definitions, as Professor Gold spoke about. One is just having the access to the document, the piece of art, the photograph, the publication. That is one dimension of open access, of having access to it. But another important dimension to really realize the promise of open science and open knowledge is actually having then the legal right to do something with that creation. And so, I may be able to read a book, or I may be able to read a publication, but if I want to remix it or reuse it or republish it, I need to have the legal right to do it. And as was discussed by Professor Gold, really the default is copyright. That is, when you create something as a creator, whether that's a photograph or a piece of art or a written story, or more likely for the audience here, a publication, in most cases, the copyright is automatically yours. And if others want to use that piece of work, they can't. It's all rights reserved. And so how can we enable access to that knowledge that you produced beyond just being able to read it? To really maximize its potential, someone downstream should be able to remix it and reuse it. And that is where Creative Commons comes into play. 25 years ago, Creative Commons created a suite of licenses that work on top of copyright. They are copyright licenses. They are free and easy to use. They're standardized across the world and give permission for others to use and share your work. They work on top of the rights that you as a creator have to your copyright to give others permission to remix and reuse the work depending on the license that you choose. Okay, so what options do you have when you want to use a CC license? So very generally, we have 6 different licenses that have different components or elements. Our most permissive license is our CC BY license or our attribution license. That's the license that we generally recommend for knowledge producers because the most permissive license allows the most degrees of freedom or the most downstream uses of your work, so people can remix it, reuse it, translate it. But as was discussed, open science is really about being as open as possible, but as close as necessary. So there may be conditions where you might need to use a more restrictive license. And CC empowers creators to have options from a very permissive license to a less permissive or more restrictive license. So you have the choice to pick a license that might have a non-commercial component. So you may want to share your work. All of our licenses require attribution, but you could add a component that says, I don't want this work to be used commercially. Or you might want to share your work with a share alike condition. And that means that anyone who creates a derivative from your work that is openly licensed with the CC license has to have the same license applied to the derivative work. Our most restrictive license would have a no derivative or adaptation component. So that means that you can share your work and it can be reposted, but you can't make any derivatives or changes to that work. Again, there's a spectrum of options because the CC licenses can be used on a wide range of different types of creations, again, from photographs to paintings to books. And in those cases, there might be creators who want to pick more restrictive terms. But if you're a researcher, we really recommend the CC BY license because generally, you are not looking for sort of a commercial use of your work. Of course, as Professor Gold talked about, there might be conditions where there might be some commercialization, and you might want to pick a more, you might be thinking about more restrictive licenses or maybe not licensing your work at all. But generally, you're going to see a lot of CC BY licenses in the research and knowledge production field. So if you go to an open access journal and you look at the licenses that they use, they generally use a CC BY license. Our licenses are standardized, meaning that if you CC license in one part of the world, it is recognized in a different part of the world. And they're used in so many different parts of knowledge and creations. You'll see them on Wikipedia. So if you go to Wikipedia, you'll see the CC licenses there. Flickr uses CC licenses. We work with a lot of libraries to CC license their repositories. We work with galleries and museums to CC license their materials, because when you have a license, it explicitly gives permission for others to use those creations and that work. So when we're looking at specifically research outputs and thinking about open science, where can I apply that CC license? So again, the CC licenses allow this reuse of the material. So beyond just reading it and physically accessing the knowledge, it allows you to do things like translations and new creations, which we'll talk about next. So as a copyright holder, so when you create something, if you're the author and you don't have some other type of arrangement with your employer, or you're sometimes when you're a government official, those are under different conditions. But generally, if you're a researcher who's at an institution, you generally hold the copyright of the publication or preprint or data structure image that you might be creating as part of your research. So if you're the copyright holder, all you have to do is add a license to the output, and it's absolutely free. You don't have to write to CC to ask for permission. You don't have to fill out a form. You just mark your document with the license as the copyright holder that you want to apply to your work. So you could add it to something like a preprint, giving others the ability to remix your preprint, or a publication. Like I said, many open access journals use a CC license and often the CC BY license on their on publications. There's conditions where data can also be licensed. Again, there it's really to give legal certainty to reusers that they can use your data, that they can do more than just access the data. They can reuse it, they can remix it, as well as images. Like you might have some microscope images, or you might have an image that you took of your model organism or your field site, and you can CC license that image so that other scientists can build on the knowledge and creations that you produced as part of your research. And so what could that look like? What can a downstream use look like when you enable CC licenses, when you CC license your work? It can be translated into other languages. In many cases, if something has an all rights reserved copyright, I can't translate it from one language to another. But with a CC license, you give permission to do localization. It also means that like your work can be converted into something like a textbook, where research that you're producing could be integrated into educational materials. Like I mentioned, it can be translated. Like you might have written something in English because that is the language of science, but you want to make it available to your local community, or someone else volunteers to try to do the translation and the localization. With a CC license, you explicitly give permission to do that. You could also enable science communicators to make videos from your work, because it has a CC license. You're giving that explicit permission, and they don't have to come and ask you for permission. The CC license says these are the legal rights you have to the work that I am sharing. Another great example that I like to give is having your knowledge be moved onto accessible platforms like Wikipedia. I've mentioned that a couple of times before. It's much easier for editors to pull information that is CC licensed into a platform that has CC licenses, that use CC licenses on their platform. Ultimately, adding a CC license, and ideally a permissive license, allows the full potential of downstream use and discoverability and potential of open science, moving beyond just accessing the information or accessing the paper, and being able to build on that paper with that license. So what are some of the examples that we like to talk about here at Creative Commons about how our licenses have enabled some really cool downstream discovery and better understanding of our world? The first one comes from the Global Biodiversity Information Facility. So they use CC licenses on their data. And in a paper from, I think, 2012, the researchers used data from the Global Biodiversity Information Facility, which they were able to access because it's CC licensed, and were able to show that the popular pet and vector, unfortunately, for rat lungworm disease is a very effective vector for rat lungworm. And so the African land snail is about like a rabbit-sized snail that actually exists in many regions, probably where I have where our audience might be at. And it generally is very climatically limited. So it's a snail that doesn't really like the cold. I don't blame it, meaning that, you know, the transmission of this disease is generally limited to the climate that the African land snail can live in. But by using openly accessible data, the researchers were able to see that it also happens to be a very popular pet. And so this giant African land snail can exist or is existing in areas where it's not climatically limited, in areas in like the Northern Hemisphere where it's not endemic to those areas, but is being moved to those areas because of the pet trade. And what that ultimately means is that these areas that normally would not be susceptible to transmission of the rat lungworm by the African land snail are susceptible to that because of this pet trade. And all of this was discovered because of openly accessible data. And of course, great inference work by these researchers. And the last example that Creative Commons likes to surface comes from the UK National Museum. So this is specifically, an example where we're seeing how open data can help us understand the effects of climate change. So the UK Natural History Museum has a really extensive collection dating back hundreds of years of butterfly specimens. They had about 180,000 digitized butterflies. And those digitized butterflies are CC licensed, meaning that a researcher that is not affiliated with the Natural History Museum or is affiliated, just any researcher can go in and look at the digitized images of butterflies and look how they've changed over time. It's this archive that allows you to go back in time to see how butterfly sizes have changed with temperature changes induced through climate change. And what they found was that as the climate is warming, the butterflies are getting bigger, particularly in their earlier instar stages. And that has an effect on what they're eating and how they're able to move. And they were able to discover this because they had access to an openly accessible archive that allowed them to essentially go back in time. These are the types of examples of what you can enable when you leverage copyright and your rights as a copyright holder to openly license information to make it easier for others to build upon your knowledge. So ultimately, open licensing enables open science. It's a critical part of open science, and CC licenses are an important infrastructure that underpins, the legal right to share and then the legal right to reuse and remix, to build, to allow others to build on the knowledge that you create. With that, thank you so much. And I think we'll have time for questions.
Thank you so much, Monica. Yes, we do have time for questions. So that's the first thing I will ask our audiences to either raise their hand or put your questions in the chat, your comments in the chat. Thank you, Mr. Andres, for sharing the link to Zenodo, which is actually a very powerful general use repository, open access repository, operated by CERN and I think launched by OpenAir under some European fund or initially to include products of projects under Horizon. But now it's broadly used around the world. It also provides the DOI, the digital identifier for publications. So this is also a very powerful tool and platform. So while our audience think about questions for both Monica and Richard, following up on what both Monica and Richard shared with us, I would like to give a few more examples of IP right management tools that enable open science. Beside Creative Commons licenses that we just heard about, not sure if you see my slides. Okay, maybe now it should be visible. Yes. And please, Monica and Richard, correct me if any of this is not accurate. So we also have voluntary licensing, allowing researchers and institutions to define the term under which their work can be assessed and reused. Creative Commons, Monica explained, providing standardized frameworks for sharing creative works while ensuring proper attribution and defining permitted uses. I just want to say that also every UNESCO publication is open access and uses CC BY licensing. Thank you for that, to Creative Commons enabling this.
Yeah, thank you.
Development licenses also allow research outputs to be shared and modified within a defined community while maintaining certain restrictions. Open source software licenses are broadly used, permitting the use and modification of software. This includes these days a lot of applications, provided that derivative work remains open, and then patent pools and cross-licensing, which facilitates collaborative innovation by allowing researchers to share patented technologies on their agreed terms. I think many of the examples Richard shared with us are in line with this. So we do have a question from Timor-Leste, and after that I want to hear from our participants if they have used any of these open science IP right tools. So yeah, I think Jacinta from Timor-Leste, hi, she's asking us for more specific examples of copyright. Or, yeah. Jacinta, would you like to elaborate your question also if you're looking for examples in a specific field? Or maybe we can just hear more examples or more simplified examples from Monica.
Yeah, I mean, I certainly do. I should say that I'm an ecologist by training, so I feel bad answering this question with the lawyer in the room.
Okay.
But my simple understanding as someone who is not a lawyer is that copyright is automatic. So I think Professor Gold explained that it's not ideas, it's not facts. So I like to give the example of like if I look out my window and I count the number of trees that are out there, I can't copyright that. That's a fact. There are 2 trees outside of my window. But if I take, a Post-it note and I draw the trees that are out there, I've expressed it into like a drawing. That automatically is my copyright. And I think that's a really important thing for particularly researchers. I guess, as has been mentioned, it's not something that we're really taught in like our methods classes. And it's important to know that like when you create something, when you write it down, it becomes your copyright. And then as a copyright holder, you now have rights that you can exercise, including adding an open license. So copyright is kind of everywhere. And as was described by Professor Gold, is that it initially and in many cases it's created to protect creators, right? So that like you can make money from the work that you're creating, or incentivize the creation of new works. But in many cases, it's also sort of been co-opted by corporations, and that's why we're seeing those like 50 to 70 years when that was not the initial copyright terms in at least in Canada and the United States. If they've been elongated because of corporate interests in maintaining and holding onto that copyright.
Thanks. I think the example made everyone understand it, but I would like also to ask Richard if he has anything to add on this.
Well, I think Monica got it right. I mean, all of us every single day produce many copyrighted works, right? You write a list, your shopping list of what you want to buy because you're going to, go to this store, and you order it in a certain way because, when I go to the grocery store, I write my list by aisles that I'm going to go through. So that's copyrighted. If my kids answer an exam question in writing, it's copyrighted. If you are a musician and you write something down, it's copyrighted. What isn't is just like conversations which are unplanned. So this conversation right now, the words we use are not copyrighted, but the video of us talking is copyrighted. So there's copyright everywhere. We are constantly producing works that are copyrighted. We're constantly violating, infringing on other people's copyright, but nobody cares because, that's life. But it's everywhere. For a scientist, I think Monica really went through it, but it's the images that might be in an article. It's the construction of the data set, not the data in it, but how we organize it, and the fields we choose and what we choose to measure and not. It's the writing we put down. If you use videos to communicate it, it would be the video of it. It's your lecture. When you go to a conference that you've planned out, you've got a script, that's copyrighted. So it really is pervasive in our lives. And it's free. It's get it. Unlike patents and trademarks, which you have to pay for.
Yeah, thank you so much. And I think for the case of Timor-Leste especially, this is a very important topic. Timor-Leste has been taking 2 crucial steps recently. One is shaping their first national research ethic committee, which of course also gets involved with copyrights a lot, and also the first online repository for sharing the outputs of scientific research in Timor-Leste. So I think, Mana Jacinta, if any further, capacity building for the committee and for the people, for the research community in the country is needed, we would be very happy to support that. Going back to the examples and, enablers of IP rights, I would like to ask the question from our participants if they have been practicing any of what we just shared. So Fitri, could you share the slide again?
While you're doing that, can I suggest you add one more, which would be the open hardware license. So it's the equivalent of Creative Commons, but for hardware.
Yeah.
which is increasingly important in synthetic biology. It's actually that license rather than the Creative Commons. But they're all of a fan and trying to do the same thing.
Thanks.
Yeah, it's a good point, that I didn't raise, which is like the Creative Commons licenses are they're like built to work on like images and like text, but we don't recommend them for software and, as Richard mentioned, for hardware. And there's actually many tools that will sort of walk you through like what license is best for me. Because these are legal tools, and so you want the sort of the deed to be consistent with like the use that you need it. And so you don't want to use a Creative Commons license for software, and you don't want to use a software license for a book you've written.
Good point. And actually, that was a question I had to clarify a bit. What can be used for what? Not sure if we can still add it. Otherwise, the point is.
I mean, one of the things that Creative Commons did, is it 25 years ago? I can't remember when it started.
Yeah, it's our 25th. It's our 25th anniversary this year. So yeah,
it is simplify this. So they take. I mean, they've got 3 layers, and you don't have to be a lawyer. There is a version for lawyers, although there are multiple versions because it depends on the country. There are some that are machine readable, so a machine would recognize whether you could use it, but it's very simplest. It's nice to say it's a simple license, the CC BY, but there is so much underlying that. So what the Creative Commons really did, and others are following, is just make it really understandable by putting them into types. But you do have to pick the right one, because underlying the overall message, there's a lot of things happening that's kind of invisible and won't apply to everything under the sun. It depends on what you're talking about.
Nice. Yeah, so I'm not sure if everyone sees the answers, but I see the answers. And Fitri, if you can share the screen. We do have examples of voluntary licensing and Creative Commons and open source software. Among our participants, they have used this. Hardware licensing, not yet. It's good to know about that. And patent pools and cross-licensing, which needs like a good base of collaboration actually to be done. And development license. Yes.
I mean, there is an example. There's the Swiss Technical University. There's researchers who are working on, what are they called? Microscopes at a very fine level. My brain is not working perfectly now.
Like scanning electron microscopes.
And so they've developed open hardware for particular uses. And this is really useful for the manufacturers of hardware, because they don't want to come up with a general tool. And they don't have the resources to say, well, it's good for this particular application or that one. And so they actually work with the community who are building these open hardware applications. So you can basically customize this generic microscope you buy for your use. So this is actually, really pro-competitive as well, because the industry is happy that people find new uses for it. So again, it's not opposed to intellectual property. What it does is it opens up all kinds of different opportunities and new uses of existing knowledge. And you have someone who used it.
Yeah, that's great. Please, if you have links or more information about the initiatives you had and where you used these IP mechanisms, please share them with us. We would be very happy to invite you to share your experience in the next sessions of the webinar. So thank you very much, Richard and Monica. I just want to ask if you have any closing message or sentence for us and our audience.
No, I'm just happy people are engaging with this, and just like UNESCO is willing to help out, we are too at Conscience, conscience.ca, and I'm sure Monica and Creative Commons they do a lot of outreach and education about this. So just reach out to any of us if you need any assistance.
So yeah, this is
Yeah,
a good point actually. Yeah, Monica, sorry for
I was just gonna
interrupting,
say,
but
yeah, our goal is to have more folks adopt the licenses, because we see the effects and the potential of openly licensed knowledge. And so yeah, just to echo what Richard said, is that we're here to help.
nice. And I just want to repeat for the people who are new today that these webinars are just the first phase of a project on capacity building. It's more about awareness raising on different topics. It will be followed actually by development of an online course with different modules on technical aspects of open science. So we hope to engage again with Monica and Richard to develop those parts of the project, and that can be used online for all the countries, for all science stakeholders. Specifically, we are targeting the young researchers who will build the future culture of science. Our next webinar, we will plan it for 2nd of July. Usually we have at 12 or 10 in the morning. So please keep in touch with us. We will share more information and registration link. Yes, it's there. So please scan the QR code to access the page. The link is also in the chat. If you find these webinars interesting and useful for your community, feel free to share the recording of the previous webinars and invite them to the next session. We will have at least 3 more sessions in the next 3 months. We are aiming, based on your input through the previous sessions, to cover the topics of enabling open science through more systematic approaches, through policy making, reforming the evaluation system for science and providing incentives. Also, exploring a bit more engagement with societal stakeholders, participatory science, citizen science. I was not sure. I mean, until now, we were not really, there was not so much focus or demand on open source softwares and hardwares, but I think with the discussions that we had today, there might be. So please let us know what you need to know about open science, what other topics you wish us to cover. If you can contribute, please inform us. We have managed to mobilize a few very good speakers during these last 7 sessions through your outreach to us. And soon we will send you a survey to evaluate our work and how much impact it had on your understanding of open science and engagement on open science. Thank you so much, everyone, for your participation today. See you next month.